the main concern right now on the part of law enforcement and intelligence is to say we're not even getting that basic information that we need to determine if an investigation is required or not. So they're facing a high degree of uncertainty in terms of potential targets or potential events because of the lack of that opportunity to do even that preliminary investigation that they can run away with, as I said, and do some initial work to find out if an individual is involved in some sort of nefarious activity.
Welcome to Inside Policy Talks, the podcast of the Macdonald-Laurier Institute. I'm Christopher Coates, Director of Foreign Policy, National Defence and National Security here at MLI. Canada faces growing threats to its security, from foreign interference to money laundering to illicit drug production. Canadians and their leaders must understand the actors behind these threats use every opportunity to achieve their goals, and that includes taking advantages of gaps and weaknesses in our laws. That's why some of the current national security legislation before Parliament, like Bill C-2, matters to the safety of Canadians. The bill proposes to give Canadian authorities lawful access to certain electronic data that is crucial to combating threats posed by foreign adversaries and crime syndicates. Right now, these groups are exploiting modern digital communications faster than Canadian authorities can adapt. Our national security agencies need updated laws to address this. But access is balanced against privacy concerns and protections in Section 8 of the Canadian Charter. So, what new powers are needed? How would they be used? And what is the risk if these changes are not made? To unpack this, I'm joined by Dr. John Gilmour, a senior fellow at the Institute. John is an expert in terrorism, counterterrorism, and intelligence. He's worked in government, in the security and intelligence arm of the Privy Council Office, as well as with Canada's spy agency, CSIS. Now, John is an instructor at the University of Ottawa's Professional Development Institute and Carleton University's Norman Paterson School of International Affairs, and he advises on national security and law enforcement. Before we get started, please remember to like and subscribe. It really helps us reach more people with these ideas. John, welcome to the podcast.
Christopher, it's my pleasure to be here.
Thanks. John, I understand you're coming to us from New Zealand today, so thanks for making the time to join us and be part of this.
Well, thank you. Actually, my today is your tomorrow.
Yeah, and we're living your yesterday. So, John, today Parliament's considering some new legislation, Bill C-12, as I mentioned in my opening remarks, which includes a section called Timely Access to Data and Information. This is getting a lot of attention by commentators, some saying that it goes too far. I'd like you to help us try to understand what is being proposed in the bill. Specifically, what kind of data would this empower Canadian authorities to access? Under what conditions, and which agencies would gain access? So can you tell us about what it is that actually is the subject of this lawful access?
Yeah, thank you, Christopher. So those two provisions essentially are enable officers, law enforcement officers or intelligence officers to seek very preliminary information in support of their investigations of individuals. And if I may, Christopher, use you as an example here.
Sure.
If you are already a target of law enforcement or intelligence agencies, let's say, for example, you undertake a number of phone calls to a particular individual, and that's identified and recorded, then that person, in the interest of investigations, becomes a person of interest. Now, what law enforcement or intelligence agencies have to do, obviously, is to determine the extent of that person's role in any sort of potential offensive offense, criminal offense, or anything along those lines, and even to start off their sort of investigations of that particular individual. They have a need to seek out very preliminary information to establish the nature of the relationship between yourself and new person ABC. And that starts off with accessing very, very preliminary information. As I said, in this case from TELUS or from Bell or from Rogers or something along those lines. So there are two elements to the new provisions in the bill. The first one will enable a law enforcement officer or an intelligence officer to go to, in this case, a telecom provider and ask for very basic information from those enterprises related to the relationship between the services they provide to the individual who's individual ABC. It's very basic information at that stage. It is, do you provide services to that individual? What's the nature of your services to that individual? If you provide services to that individual in Canada, what's the province? That sort of thing. There is no request for detailed history of the relationship or the contents of communications or anything along those lines. It's very, very basic preliminary information. And that information is used in turn to see if there's a need or a rationale to investigate person ABC further. So it's very preliminary information.
So if we
The
use your
second part,
example, sorry,
I'm
if we
sorry?
use your example, John, so then, and I was that person of interest and I was having communications with somebody, what you call a person of interest, then law enforcement could go to like a Rogers or a Bell and ask if they have a, a service contract with that person of interest. Is that
Essentially, yeah. And that's pretty much as far as it goes. And some of the information around the nature of that contract. Again, is it in Canada? Um, uh, do you provide other services to this individual, or do you know if anybody else provides services to that individual? And that's the sort of limit to the information that can be requested under that particular provision under the Act, or what's called a demand order. The next level up, if you will, is a bit more intrusive. A judge, actually, on the part of a law enforcement or intelligence agencies, has to sign what's called an information demand. And the information demand is then given to the TELUS or the Bell or the Rogers, and essentially it's asking for a bit more bit more elevated information. The premise here is, we know you have information on this individual, and we need a bit more detailed information. We need the account number, maybe the email address, maybe the account number if it's a bank, that sort of thing. So they're looking for the next level up. But again, it's not intrusive. They're not looking for historical records. They're not looking for the content of information. The whole purpose of what they're trying to do is to determine if the person of interest, person ABC, is connected to the actual target in some capacity or not. And more importantly, if he or she is, it provides the information, the necessary information, to go ahead and potentially develop more detailed information if you have to do more intrusive investigations that require a warrant. In other words, the very preliminary information that you're getting through the two steps reflected in the new bill is really a stepping stone to deeper, further investigations down the road, if warranted.
okay, John? Thanks. That's helpful. Let's just focus on sort of that demand level of information, the first level that you talked about, that didn't require the intervention of a court or a judge. Why do authorities, and you may have said it, but I just want to try and make it perhaps a bit more understandable uh, to non-specialists. So why do authorities need the access to that data? If you can put it in the example, in the context of the example that you used, and then what kind of security threats is that meant to address? So either security or law enforcement threats. So that demand level information, I'm talking to somebody, a person of interest. Why do authorities need access to that demand level information?
It's really step one of the investigation, Christopher. It's for them to get even the basic information on somebody they may not know or has never been on the radar before. They will get that sort of relationship or information under the demand order, just to see, based on, again, very preliminary information based on what they get, whether the person is even involved or even connected in some nefarious manner to the plot that you are plotting right now. So it's really just it's step one, and that's the reason why it's very basic information. They'll run away. The law enforcement and intelligence agencies will run away with that very basic information and do their own work based on the technological abilities that they have or the investigative capabilities that they have outside of a warrant. And they may get sufficient information from that to proceed, but it's mostly to make sure that A, they're operating in the right jurisdiction, if it's law enforcement or if it's national security. And secondly, it's really just to ensure whether the person, rather than spending a lot of effort on an individual, is warranted or not, whether they're connected to a plot, whether they meet the thresholds for further investigation or not.
Okay. What prevents law enforcement or security, like intelligence officials, from getting that information today from Canadians?
It's primarily driven, Christopher, by the nexus of privacy concerns to investigation, and there's always the view that any sort of increase in privacy, increase in investigative capacity impacts on privacy. But right now, the concern right now is that any sort of investigation of or search for information, even at the preliminary stage right now, is considered privacy under current laws. And you need a warrant in order to get even that very basic information.
So, what's the impact, John, of having, if our law enforcement and intelligence officials need to go get that warrant to get that basic demand level information? What's the impact of that today?
The need for a warrant, certainly in the intelligence world that I'm more familiar with as opposed to law enforcement, but to get a warrant, the warrant has to be detailed. It has to be very thorough. There has to be enough information contained in a warrant to suggest that the investigative can proceed down a path that starts butting up or even exceeding charter rates, Section 8 of the Charter. And as a result of that, because of the need to undertake so much time and effort to generate a warrant, even for basic information, you may lose the opportunities to take advantage of even the preliminary information. You may lose the ability to undertake the investigation because you've lost time, you've lost opportunity, you've lost that sort of thing. And the concern on the part of intelligence agencies and law enforcement is that as a result of that sort of time delay in getting just basic information, they use the term "we're going dark." We're losing our capacity to investigate these kinds of issues, even on the periphery, because of the time and the effort that it takes under the current regime to get a warrant, essentially just to get a warrant down the road. So they're losing investigative capacity and the timeliness and the opportunities to look at kernels of information that flow up that may flow into something more comprehensive in terms of an investigation going down the road.
So, John, it's helpful, but why today? Why is this coming up today as something that's so important? It obviously has existed up until now. So why is this so necessary today?
So there's been an ongoing history between the privacy community and the law enforcement intelligence community on this sort of issue. Christopher, it's been going on for decades, but right now there are really three main elements. First of all, there are the exponential growth in the number of telecommunication providers, whether it's various apps, whether it's other platforms, whether it's TikTok, whether it's Instagram, that sort of thing. It's just the growth of the telecommunication platforms. If we're focusing on telecommunication platforms over the past 10 years or so. Secondly, there's the volume of information that is rolling out there just because of the increase in social media or because of in telecommunications. The volume has also grown exponentially. And probably, and thirdly, the biggest concern is the ability of individuals to encrypt information between their communications going back and forth. I mean, there's a lot of commercially available encryption, Signal being one, WhatsApp being another, typical commercially available applications that an individual can encrypt their information going back and forth. And that is a real challenge, especially if we're using signals intelligence as one of the main drivers for our investigation.
Okay. Do you think, John, that Bill C2 would help address the requirements that law enforcement and intelligence have? Would it solve the problem, so to speak?
I absolutely agree, Christopher, because as I said, the main concern right now on the part of law enforcement and intelligence is to say we're not even getting that basic information that we need to determine if an investigation is required or not. So they're facing a high degree of uncertainty in terms of potential targets or potential events because of the lack of that opportunity to do even that preliminary investigation that they can run away with, as I said, and do some initial work to find out if an individual is involved in some sort of nefarious activity. They need that because, as they say, they are going dark. They have to drop investigations because they're losing time. And I think one of the former CSIS directors said this is one of the biggest concerns that we have from an intelligence perspective. So it's not a small issue. And I think yes, the bill, if it's couched in the right way, if it's presented in the right way, and what we're trying to do here is sort of present the justification of why that is the case, I think it will go a long way. There are big concerns from privacy groups that what is being proposed here in C2 essentially is sort of a warrant results in warrantless surveillance. And I don't think that's true at all because they're not going after historical records. They're not going after the content of information. Again, they are just looking for some modicum of preliminary information so they can continue on with the more intrusive investigations, if necessary, under established warrant procedures that give some level of comfort to charter concerns.
Thanks, John. That was the next question I was going to ask is what the objections were, but you've addressed that. So I'll move on. How does this same situation apply to I'll call it our Western Democratic allies? Those in the Five Eyes community, our Five Eyes partners. Do they
Yeah,
have similar provisions, or what's the situation with them?
uh, I think there's a common feeling out there that Canada is lagging behind Five Eyes partners when it comes to this sort of issue. But I think that's sort of an overgeneralization, Christopher. Certainly in the states where a lot of the social media providers are located, I think the U.S. has under their new Cloud Act they have that provision to look for that sort of information. But in the case of other countries like the U.K., what they do there is instead of having a legislation in place that say that a communications provider has to have the technology to actually provide the information, or if law enforcement or national security agency come looking for it, what they do over there is there's an obligation for the communications providers to provide records for a set period of time, whether it's 6 months or a year or whatever the case may be. So there's not an actual mandate to directing them or ordering to have the technology available to provide that information. Instead, they've taken a different approach to say you have to keep records for a certain period of time under one of their acts over there. So it's a little different approach than mandating or absolutely, being very dogmatic in terms of your ability to respond technically to our requests as is proposed in the act.
But does it achieve the similar result? Does it
Uh,
provide access to their law enforcement and intelligence officials?
in the UK?
Hmm.
Yeah, I
Okay.
think so. And I think the obligation that is reflected in section 15 of C2 is going to require a lot of work. If you are mandating a telecommunications to have the technology to respond to requests, there's going to be a raft of issues that they're going to have to look at from a regulatory basis. And it also provides for government agencies to go in and inspect to make sure that they have that capacity. So, what's an acceptable level of capacity? Is there people that can be carved out from that sort of thing? There's just a whole mess of regulatory action that's going to have to take place if this bill comes into place on that particular aspect of demanding or insisting that telecom providers have the technology to enable them to respond to requests for information.
In your view, John, we're getting close to the end. In your view, how will pressing these provisions into law help make Canadians safer?
Well, again, it gets back to the main point that intelligence agencies and law enforcement, well, be able to take advantage of immediate opportunities as they present themselves from an investigative purposes, starting right from scratch and leading all the way up to potentially more intrusive activities. But it also gives intelligence and law enforcement agencies the ability to determine if somebody is in fact connected with a nefarious activity or not, without having to go through the more cumbersome, the more time-consuming warrant process. This is going to enable law enforcement and intelligence agencies to jump on immediate opportunities with the very limited information they may have, in the interest of exploring or mitigating the potential for nefarious activities down the road, whether it's organized crime, whether it's terrorism, whether it's interference, whether it's espionage, so on and so forth.
Thanks, John. Anything else you'd like to add to help explain the situation to our audience?
Well, as we know, C2 has sort of been held back on the legislative procedure. One of the complaints from the privacy groups is there wasn't any consultation on the provisions of the access to information. I think there's going to have to be more discussion along those lines. For example, as we said earlier, is the medical or legal community going to be carved out of the definition as it's defined right now? Because the definition is fairly broad speaking. I think there's going to be lots more conversation will be required going forward to get the bill tight that's going to satisfy both the intelligence and law enforcement communities and the privacy communities. More to follow on that particular one.
Well, let's hope we manage to get after that sooner rather than later. So we're done. Thanks very much, John. Thank you for your time. Please take a moment to like and subscribe to this MLI podcast. For MLI, I'm Christopher Coates. Thank you for joining us on Inside Policy Talks.